Okay, welcome everyone to the October portion of the 2024 Employment Webinar Series. This is Jordan Schwartz, and I'm presenting with Megan Shaked. This webinar is about ADA website compliance. Megan and I have talked about this in years past, but every year there's always updates, there's new laws, there's new cases. So we wanted to give you the latest. And we're also going to talk about a few other disability-related aspects in addition to just online. I'm going to give you a little overview of Title III in general. Megan's going to talk about service animals, but for the most part, we'll focus on the website accessibility. For those of you who don't know me, my name is Jordan Schwartz. I've been here at Conn Maciel now for 10 full years since we've started. I spend a heck of a lot of time advising places of public accommodation, hotels, restaurants, stores, on all of these ADA related issues. I also do, general employment law, where I'm either in litigation or counseling employers on compliance with all the federal and state related employment laws that you're all familiar with, the ADA, Title VII, FMLA, things of that nature. And I deal a lot with non-compete agreements, restrictive covenants, non-solicitation agreements, trade secrets, and things of that nature as well. Megan, do you want to introduce yourself?
Sure. Hi, everyone. Thanks, Jordan. My name is Megan Shaked. I'm a partner out in California. I'm based out of our San Francisco office, and I participate in both practices at Conn Maciel Carey. So I participate in the employment side, doing litigation and administrative matters in with California agencies and California state and federal court, as well as advice and counsel, helping with California employment law compliance. And then I also practice in our OSHA practice, where I do primarily Cal OSHA work, though occasionally do other state plan states and help out with research assignments and things like that. So I actually started out when I joined Conn Maciel Carey doing quite a bit of ADA litigation in the area that Jordan's going to speak about, and also the area that I'm going to be speaking about, including, believe it or not, issues involving service animals. So excited to chat with you all a little bit today about this topic.
Well, thank you very much, Megan. So I'll start by just giving a brief overview of Title III of the ADA, and then I'll jump right in to talk about what we primarily think of website accessibility, which is the issues for users with visual or hearing impairments. Then Megan's going to talk more about what's colloquially known as the reservation rule, which is what accessibility features need to be listed on your website for hotels. Items 1, 2, and 4 really apply to any place of public accommodation, whether you're a store, whether you're a restaurant, whether you're a hotel. Item 3, a portion of which Megan will be talking about, is really only related to hotels. So if you're a store, for those few minutes, you can tune out a little bit. It's still good to know, but the actual statute or the actual regulations only apply to places of lodging. Again, Title III of the ADA, it applies to all places of public accommodation, any type of store, anywhere where the hotel, where someone from the public is invited. It's easiest to think about that as a hotel, but it really is a coffee shop, any place where a member of the public can go in is considered a place of public accommodation. And I'll get into in just a second, how that relates to websites. But in general, Title III prohibits places of public accommodation from denying services and accommodations to individuals with disabilities. But that's not just saying you can't come into the store or you can't come into our hotel. It's more subtle than that, and it's making someone's life more difficult if they're in a wheelchair, for example. That's a violation of the ADA. Megan and I were just talking just this morning. An article came out that American Airlines was just actually, I don't recall just the article if they were fined 500 million or 50 million. It was either 50 million or 500 million, and I'm not sure if it was if it was a fine or a settlement agreement, but it was a result of not denying people in wheelchairs from coming on the airplane, but treating them less than perfectly by either injuring them while they're wheeling them, or more likely injuring the wheelchairs while they're checked and things of that nature. And now they have to pay a ton of money because they didn't um install the proper practices and procedures to make sure someone with a disability was treated how they should be treated. So that really all encompasses that second bullet point there. The third bullet point is you must, as an organization, remove barriers to access and or modify your policies, practices, and procedures to accommodate individuals with disabilities. Between that one and then the next one, which is provide effective communication, that's where the website issue comes in. That a website, if you're a place of public accommodation, if you're a hotel or a resort, if you're a retail outlet, you also most likely have a website, then that website is going to be considered a place of public accommodation. And because of that, that's why the website will need to be accessible, and I will explain what that means. Finally, on every presentation I give about ADA Title III, I want to mention there is no grandfather clause. This is such a bit of misinformation. I see companies, I see chambers of commerce, I see all sorts of people send out communications saying, oh, you don't have to worry about complying with the ADA if your property was built before 1990, because the ADA didn't exist then. And I don't know where that rumor got started and how it's taken off so it's such a popular myth, basically, but it doesn't exist. It doesn't matter if you're the owner operator of a property that was made in 1800. You still need to comply with the ADA. Now in general about web accessibility guidance. So this past year, more than 4,600 ADA lawsuits were filed. We see it mostly in New York, Florida, and California, but it is all over the country. That 4,600 number does not take into account demand letters or draft complaints, and we probably see at least half of the lawsuits are in that form. Where the plaintiffs say, well, we're not going to file a lawsuit yet, but we're going to share with you the allegations and see where we go from here. So that number is probably more like 10,000. Interestingly, 31 plaintiffs' firms file half of these lawsuits. So yeah, we know who the key players are. They're not that many random plaintiffs or plaintiffs' firms that are filing these lawsuits. It's the same players over and over. And unfortunately for businesses, class action ADA website lawsuits are becoming more and more predominant. Megan and I are on a case right now that is an alleged class action. We're still at the beginning stages, and we're of course going to try to fight it and have them prove that somehow they can establish a class, either statewide or nationwide, to prove ADA website allegations. Historically in the past 4, 5, 6, 7 years since these claims have began, they were individual plaintiffs claims, and I'm not convinced they should be class action claims where different than if you're a company and you have all of your sales associates are filing some sort of class action for purported pay practices. Here I think it would be much harder for them to establish a class, but that's certainly not preventing the plaintiff's attorneys from trying. And with all that being said, for years and years, these ADA lawsuits were starting to be either filed or at least threatened to be filed. And the DOJ, the agency responsible for promulgating the ADA, was really silent on whether web accessibility was a legitimate claim. But finally, and really, they kept on saying, we'll issue a statement, we'll issue a statement. Years and years and years went by. Finally, in 2022, the DOJ did specifically state that web accessibility is an ADA requirement for places of public accommodation, which means for businesses open to the public. So based on that guidance, along with applicable case law, that really makes it abundantly clear that businesses should do their absolute best to ensure that their websites are accessible to individuals with disabilities. For either better or worse, though, the guidance doesn't say exactly what you as a business need to do. It might be nice if it said it, but on the other hand, it's nice that it gives you a little bit of leeway. The guidance really just states that businesses can currently choose how they will ensure web accessibility. It does talk about WCAG, the Web Content Accessibility Guidelines, as helpful guidance, and that is what you should be looking at as a company to make sure your website is accessible. And then the DOJ does talk about some examples of what you as a business should do, and I'll explain these examples in a few minutes. Provide text alternatives, video captions, providing users with a means for reporting accessibility issues. So it is at least helpful that the DOJ has provided this guidance. It may have been more helpful if the DOJ just said, either promulgated a rule or didn't promulgate a rule, but this is where we are right now with their quote unquote guidance that doesn't have the letter of the law, but it at least has some sort of weight behind it, that it's the same the same administrative agency that enforces the ADA. Interestingly, just a few months ago, I guess it was almost exactly 6 months ago, the DOJ did issue web accessibility rules under Title II of the ADA. Now, Title II of the ADA applies to public agencies, state governments, things of that nature, public employers. So if any public employers are on this webinar, there actually is specific not only guidance, there's a specific rule under the DOJ that applies to you, and it's specific, and it is now in effect, and you absolutely do not have discretion now. Some of the rules include that you have to integrate text description of images for people using screen reader software. You must provide captions on videos. You must enable navigation through a keyboard instead of a mouse. And again, the rule impacts public programs, services relating to employment, education, notably voting, health and transit schedules. And the intent is to ensure that individuals, and they're focused on students here with disabilities, can access course content. Voter registration can be improved, so individuals with disabilities can register to vote online. Basically, in a nutshell, this DOJ rule sets clear standards for what state and local programs must do to make their online programs, services, and activities accessible to people with disabilities. Now, most of you on this call are from the private sector. So this does not yet apply, that same rule doesn't apply to businesses in the private sector, but that rule is a roadmap for what will be happening in the next few years. And some states, specifically California, are starting to pass state legislation that is very similar to that rule. So it really is not worth just ignoring that rule, although it doesn't apply. If you're trying to make your website accessible, which you should be doing, you should look at the rule of Title II, because in the next few years, that's a very similar, if not identical, rule will end up being passed for your organization as well. So I at the very least, want you to start to be aware of the requirements set forth in that Title II rule and start preparing for the issuance of a similar rule. Just something else. I like to talk about some businesses being proactive, um, and especially here in DC, there's a lot of proactive initiatives going on. One example is the Starbucks signing store, where it's near Gallaudet University. And the store is really created specifically for deaf and hard of hearing customers. The staff is ASL fluent employees, and the store uses technology and design elements that cater to its customers. The word Starbucks is spelled out in sign language and things of that nature. Another Washington, D.C. Starbucks is going above and beyond what's required under the ADA, by having numerous lower countertops, good acoustic dampening for those with hearing aids, point of sale systems designed to be easier for those with disabilities, just to make the store a more welcoming experience for everyone. The other new thing is some hotels are talking about, or actually I've heard of a few that have done this, that are installing an audio format signage system. It's almost like a GPS, but for visually impaired guests to navigate the property independently with a mobile app that kind of tells them when to turn left, when to turn right, and things of that nature. I also did mention that Disney World recently changed its policies, actually restricting eligibility for services that help some people with disabilities avoid waiting in lines for rides. And the rationale they gave was that too many people were taking advantage of it, and someone in a wheelchair might, invite their entire family or all their friends to help skip the line, and it was just creating all sorts of problems at Disney. There's also, just quickly, about self-service kiosks. Those are becoming more and more prevalent at all the at grocery stores and things of that nature. And the DOJ a few years ago now filed a statement of interest clarifying that Title III does require stores or any place of public accommodation to provide auxiliary aids and services so that individuals with disabilities can fully and equally enjoy all their services. That goes with that bullet point I talked about right at the beginning, where that auxiliary aids must provide effective communication to individuals with disabilities. For a while, people weren't sure whether that included self-service kiosks, but now it is clear that it does. The big case that came out, that's been kind of all the talk of the community, who represents employers or plaintiffs in disability related cases, was Laufer versus Atchison Hotels. This case came about last year. It was argued in the Supreme Court right around a year ago, and it's worth talking about, just so you know where things stand right now. What happened was an individual with a disability, Deborah Laufer, who has filed hundreds and hundreds of these types of cases, maybe even thousands at this point. She sued a hotel company in Maine, alleging that its website contained insufficient information on disability accommodations. That's going to be the rule that Megan's going to be talking about in just a few minutes. She could have called the hotel and asked questions, but she intentionally didn't, because she really didn't even want or need the information. She was just looking to see if the information existed, because if it didn't, she would then file a lawsuit. The district court in Maine dismissed her lawsuit for lack of standing, because it said, basically, they said, you don't want to come to the property, so we don't see how you're being injured. How can you be injured to go to a property that you never planned to visit to begin with. The First Circuit, though, reversed and said just the simple fact that she was denied accessibility information, even though she didn't want to go to the property, was an actionable injury and established feelings. I'm sorry, established standings. Um, it talked about that her feelings of frustration, humiliation, and things of that nature are enough to actually constitute an injury. That ruling was in direct conflict with ruling from the other circuit courts. So, like I said, last October, the Supreme Court heard the case, and we were all very interested to determine whether a plaintiff is allowed to sue a hotel under the ADA, even if he or she does not plan to visit in the future. Unfortunately, through a lot of legal maneuvering, the attorney, Miss Laufer's attorney got sanctioned. Miss Laufer then didn't want to continue. She tried to moot the case. The defense said, no, we've spent all this time and money arguing this case. We want a ruling from the Supreme Court. And for some reason, the Supreme Court still decided to hear the case, but then they said that it was moot because the plaintiff wasn't pursuing it anymore. So after all of that back and forth and waiting, the Supreme Court still has not weighed in on this issue, and we still do not have any more guidance as to how they would rule on this issue, which is really unfortunate because if an individual isn't coming to the hotel or doesn't plan on coming to the hotel, it would be very nice to be able to argue that he or she has no standing, and we still do argue that and have been successful. But it would be really nice if we had the Supreme Court's blessing in making that argument. Okay, in the last few minutes here, I'm going to talk about this first square here. Does your website need to be accessible for users with visual, hearing, and physical impairments? And the answer is generally yes, and how that should happen. Then Megan will talk about what information your website actually needs. But going to my issue here about the individuals with hearing or visual impairments. What happens here is that an individual with such an impairment uses what's called screen reader software. They download that on their computer, and then your website needs to be compatible with that screen reader software. As I mentioned, although the DOJ doesn't have specific rule on this issue, it has issued its guidance saying essentially your website needs to be accessible, which means it needs to comport and be compatible with the screen reader software. And almost all courts have ruled on that issue in favor of websites needing to be accessible. I will mention real briefly one court that came out the other way. Years ago, a few more courts were coming out the other way, but right now it is probably be a fool's errand to rely on, the one or two outlier cases. So what you want to do is make sure your website complies with WCAG. And right now, the latest version is called 2.2. Yeah, as of 2020, it was WCAG 2.1. I think in 2020, I'm sorry, it was 2.0. In 2021, WCAG 2.1 came out. There's just a few updates and a few additional changes. And now the most current version is WCAG 2.2. I'm not going to get into the technical aspects of what that means, but you should just know that should be what you want to comply with if possible. And I'm not going to talk much about cases. This is just a big case from 2019 because someone in California tried to order from Domino's. The website was not accessible. Domino's fought then the individual sued. Domino's fought the lawsuit saying since there wasn't an actual rule from the DOJ, they were denied due process. They lost. The Supreme Court denied cert, which essentially rubber stamped the Ninth Circuit's decision that said Domino's and other places of public accommodation needed to be accessible. Their websites needed to be accessible. This is the one case I mentioned that the 11th Circuit in 2021 said that websites are not places of public accommodation. I think this is Alabama, Louisiana, and it does include Florida. But this case is an outlier, and I just would not rely on it if I were you. Okay, last few minutes here. I'm just going to talk about what the website accessibilities are. One is menus in PDF format. If you're a restaurant, if you're a hotel, and someone needs to download the menu in PDF to read it, most likely that is not accessible. It's not 100%. It's possible you can make your PDF accessible, but more likely than not, that is not accessible, and you are exposed to a lawsuit just by having that PDF. It would be much better if you can just have the menu on a Word or other document that is not PDF that your IT team can make accessible. Other common issues. If you have pictures, if you have symbols, if you have maps, which you probably do, and you have no written descriptions, you should have, the alternative text. You should have pictures and you should have descriptions. If there are videos, the videos should have video and audio files with closed captioning. Having no captioning is an issue. Navigating a website should be able you should be able to do it through your computer, through your keyboard, or through a mouse. Sometimes a hotel will go through all the effort to make their entire website accessible. They've spent thousands of dollars and hours making their website accessible. And then when you go to book your reservation, you've done a user goes and does all the work to reserve, and then they have to press confirm. And the only way they can press confirm is dragging their mouse and then clicking on the confirmation button. But the confirmation button is blinking, and if you don't have a way to use your keyboard, and if you have to use a mouse, someone with a visual impairment will not be able to navigate their mouse to the exact spot where they need to confirm their reservation. And having a hotel website with a user not being able to book a reservation is probably, one of the biggest issues you can have, whereas a user with a disability is going to be frustrated and then bring a lawsuit because they wanted to visit your property, but they were prevented from doing so. Just saying, oh, well, then they could have called and booked their reservation that way is really not at all a sufficient defense to a claim, because someone without a disability doesn't have to call. So someone with a disability shouldn't have to take an extra step just because your website didn't provide proper functionality. So what you want to do is, you can talk to Megan or me about how you can go about retaining an accessibility consultant to review your website. If I was giving this presentation about your property, I would also want you to review an ADA, retain an ADA consultant to review your property and make sure you have the proper grab bars in your bathroom, and make sure you have a ramp instead of steps or in addition to steps, and things about the physical nature of your property. But for these purposes, for this presentation where we're talking about website issues, you should retain an accessibility consultant to help review your website and see where it's lacking from an accessibility standpoint. Just finding a widget online, which you can do, and say, oh, I can just have something kind of through like AI that it can look at my website and tell me where it's accessible and where it's not. That is just not sufficient. You need an actual consultant and an actual human being to really look and see where you're compliant and where you're not compliant. The widget is kind of known as like a Band-Aid defense, and it just won't find everything. And some plaintiffs will see that you used a widget, and they may be even more emboldened to bring a lawsuit. But what you need to do is get Megan, me, or if you have other legal counsel that you use, that's fine. You need to get legal counsel involved. They don't need to spend a lot of time and a lot of money. You're not going to be double paying, but you at least need the ADA website consultant to be reviewing your property based on the advice and counsel or at the direction of legal counsel. That way, attorney-client privilege is maintained. If you just get a consultant and you don't have any lawyer attached to it, and then next week you get sued, and the first discovery request they're going to ask is, show us your website and any reports you have regarding the accessibility of your website, and you might have a report from a consultant saying all the different ways your website is not compliant with the ADA, and I'd rather you not have to turn that over to the plaintiff. I do want you to have that report so you know how to make your website compliant. So the way around that, again, is just to have legal counsel involved. Then you have that report, you can use it to your advantage, and you will not have to turn it over to plaintiff's counsel in discovery or really at any time. I'm just about done here, and I'll turn it over to Megan. The other thing what you do want is an accessibility statement on your website. In addition to having your website compliant, it would be really nice to have a statement that accomplishes a few things. One, it says you're compliant. It says, hey, just so you know, we have, done an audit and we are now in compliant with WCAG 2.2 or whatever you say. We have a few paragraphs we write to make it clear to anyone looking at the website that it's compliant, to help them use the website, so that someone knows that the website and your store or your restaurant or your hotel are compliant and accessible to both when they get to the property and through the website. And it should provide a phone number, email address, and contact person for questions regarding anything under the ADA. As I said before, you can't just say, oh, you should call the hotel instead of using the online access. That's not sufficient. But providing a name and number so that someone can call with additional questions is certainly a good thing. Other times, again, an individual might say, oh, I tried to use the website. I couldn't. There was no one to contact, so I had to bring a lawsuit. So it certainly is good to provide your phone number. And there have been cases that have turned on whether a place of public accommodation had an accessibility statement or not. So it's really well worth a few hours of your time to talk to an attorney, someone like Megan or me, just to help you have an accessibility statement on your website. Because I'd hate for just the lack of that statement to be a potential impetus for a plaintiff to bring a lawsuit. And now the last question to end this topic, and I've seen this a few times. Let's say you've already been sued for ADA violations relating to your website. Can you then be sued for that exact same issue? And let's say the first time you resolve the case, you decided to settle, you entered into a settlement agreement saying you would make the website accessible, let's say in a year from now, and then 2 months later, you got sued. The answer, of course, is yes, you certainly can be sued for the exact same issue. So what I always recommend to our clients is to make sure you make the changes as soon as you practically can, as soon as possible. If you enter into a settlement agreement with an individual plaintiff, that one plaintiff cannot sue you for the length of the settlement agreement. You might have a year to make the changes, but every other person on the planet can still sue you. So until you actually make your website fully ADA compliant, there's a lot of legal exposure out there. And just saying, well, we have a settlement agreement. We told someone that, we're in the process of making fixes, that doesn't really cut it. So as much as you can, as soon as you can, really just, kind of don't sit on your hands. I want you to retain an accessibility consultant, look for ADA issues, and if there are ADA issues, fix them as soon as possible. All so you can reduce your legal exposure and, help with accessibility in the community, which is another good goal. On that note, I will now turn it over to Megan to talk about information about accessibility features.
Thanks, Jordan. So yeah, we're going to transition to talking about not rather than how you access the information on the website, really the content of the information about the accessible features of your hotel. And this is the section that Jordan mentioned is particular to hotels. So that's why I'll be speaking about it in that context. So just to kind of start out with some foundational concepts, give some high-level requirements that stem from the ADA regulations themselves, and then we'll drill down into some more detail. So starting out, one of the kind of foundational concepts is that a place of public accommodation that owns or operates a place of lodging, so we're talking about a hotel, has to modify its policies to ensure that individuals with disabilities can make a reservation for accessible guest rooms in the same manner that any other individual can make a reservation for any other room. So if a general member of the public is able to access a reservation system online to reserve a room, then that same process needs to be accessible for somebody seeking an accessible a room that meets their accessibility needs. So it's not sufficient for a website to say, hey, give us a call if you want to reserve an accessible room. It may be that you provide a contact information to answer questions or help navigate customer service concerns, but the actual reservation, if it's available for general members of the public, there needs to be a way to reserve an accessible room. The next concept on the next slide is that, again, foundational concept from the regulation, is that your reservation system has to work so that if a person reserves an accessible guest room, that those rooms are available until the rest of the rooms are, excuse me, let me rephrase this. So this requirement stems from the fact that you can't have the accessible rooms available to people who do not have accessibility needs first. So you have to hold these rooms until all other guest rooms have been rented, so that those remain available for use by somebody who needs the accessible features of that room. So you're kind of placing those, not just first come, first serve for all purposes, but that those remain available for somebody who specifically has the accessibility needs. But then once all of the rooms in the hotel are booked, then those rooms can be available for members of the public, as well as individuals who might need the room specifically for their accessibility features. The third concept is that, and there's two requirements on the next slide you'll see for the regulation that are about kind of holding the room. So if somebody selects an accessible room for booking and books that room will be held. And not only that, but not just an accessible room will be held. The specific room that the individual selects will be held. And this is to protect against a situation where somebody might choose a particular accessible room, and the host might give them an accessible room, but not the particular room they selected. So maybe they selected a room with a roll-in shower, and when they go and they show up at the hotel and they go to check in, the hotel says, oh, well, the room with the roll-in shower is no longer available, but we can give you the accessible room with a bathtub. That would not be sufficient if the person, in fact, selected the room with the roll-in shower. That needs to be held for them. And then finally, on the next slide, this is the concept that I'll spend a little bit more time digging into the details, which is that the hotel website has to identify and describe the accessible features of the hotel in general and the guest rooms more specifically. And it has to provide details that reasonably permit the individual with disabilities to assess on their own whether the hotel and the guest rooms meet their specific accessibility needs. So here is where, at a minimum, we can give you some guidelines about the information that you want to have available on the website. And we often see this in a couple of different ways. Sometimes there's, excuse me, a more general portion of the website that has the accessibility features of the hotel. And it might describe things like how you access the front of the hotel or how you access reception, whether some of the common areas of the hotel are available and what the accessibility features are for that. For example, having a pool lift for the pool. And some of that information, it's great to have a general section, maybe it's a tab on the website where you can go and get some general information about access to the hotel, through the front door, through parking areas, what the paths of travel are to the different common areas, and what the general areas are, what the accessibility features of the general areas are. But if you do have a section that's kind of general like that, it's also really important that you reference where else on the website you can go to get specific information about accessible features of the individual rooms. So you might have this portion of the website that has information, but then maybe reference, or you see these other pages or see these other tabs or another portion of the website for specific information about rooms. You might say something more generic, like we offer accessible rooms. For more information about the individual features of the room, see, a different section of your website, for example. The information that has to be provided about the rooms, there is, some general rules of thumb to keep in mind, but sometimes, and this is where Jordan and I will, get into the details with opposing counsel in, litigation is, what is enough information? But good place to start out is that you want there to be some basic information about the features of the room, including what type of bed, right? So is this a single bed? Is this a king bed or a queen bed? How many beds are in the room? Is it, the kind of room that you can have somebody with you, or is there an adjoining room where you can have somebody who assists you in the room next door with the door open? What does the bathroom look like? And that can include things like, does it have a roll-in shower? Is the bathtub have accessible seats? What are the availability of grab bars or any other feature that somebody who's trying to figure out, is this room going to meet my needs? What is the type of information that they would need to know? And that's, again, the information that should be available on the website itself, so that if somebody is trying to figure out, okay, this says it's an accessible room, but what does that really mean? Because I need X, Y, or Z, and I need to figure out if this is the right room to book, or if, a different accessibility room that you might offer is the better choice. Another thing to note that we always want people to be aware of is that we did see a trend starting back a few years ago where plaintiffs would bring the lawsuits against the hotels, but based on the information that was available on an online travel agency's website. So, your listing for your hotel on, Expedia or some other website isn't providing the sufficient accessibility related information that allows me to decide if this room or if this hotel meets my needs. And a lot of times, it might not be clear to somebody who's, just Googling or searching online for accommodations, who is the responsible website? Where is this information coming from? So it's really important that hotels are reviewing the information that is showing up on these third-party websites about their own hotel, and that they're providing the level of detail that needs to be in those listings. And, ideally, the same information that is on your website identifying and describing the accessible features of the hotel and the specific rooms should match what's available on the third-party website. So there's no issue of, hey, this third-party website didn't provide me the sufficient information, and now I'm holding you, hotel, accountable for that. And then, as promised, we wanted to spend just a few minutes reminding folks about kind of what the requirements are with respect to service animals. This does come up from time to time. Sometimes they show up in the same cases where folks are concerned with the accessible features of a hotel, and you might understand their, a guest's needs before they show up. But sometimes guests surprise hotels and show up and, might declare that they need X, Y, or Z and didn't make arrangements for that ahead of time. So it's really good to have a clear understanding of what your requirements are for accommodating guests, and make sure that your folks are trained as well. So anyone who might be interacting with a guest that's asking for an accommodation, that they're trained on what they can and cannot do, or the person to get who might know the information. Maybe, if somebody asks for something, they know to ask a manager rather than saying, oh, I don't know, I don't think we can do that. Because you would hate to have good processes and policies in place and then have a disconnect between those and what your folks on the ground may be trained to do. So for service animals in particular, we just wanted to remind you about what the requirements are. So starting out with the definition, which is on the next slide, of what a service animal is. And it is specifically defined as dogs or miniature horses trained to perform for the benefit of a person with a disability. So there is a tie between a need that the person has and the skill that the service animal is providing. So some, guidelines to remember is that service animals are, a specific term of art under the ADA. They are different than support animals or comfort animals or, other categories of animals. Service animal is a particular definition. So if your hotel imposes surcharges or cleaning fees for pets, those cannot be imposed for a service animal. So this, of course, begs the question of, well, how do you know if somebody is bringing in a service animal versus a emotional support animal or just a pet? And it's really, really important to remember that there are only two permissible questions that you can ask a guest. One is the animal required because of a disability? And two is, what work or task has the animal been trained to perform? You cannot ask for any other information if somebody presents and says, I have my service animal. You can't charge me for that pet fee because this animal is a service animal. You can ask those two questions and that's it. You cannot require proof that the animal is a service animal, any medical documentation to support their need for that service from the animal. But there are some limits that exist even for service animals. One is that you can require that the animal be on a leash, and it's not a, free-for-all. If the animal is out of control and the owner is not able to maintain control of the animal, or if the dog is, not housebroken. So if they are, not able to go to a particular designated place to use the bathroom, then that's a limit that you can place on a service animal. So we realize that this can be a really tricky situation. It's kind of an intersection of what is a service animal, what is an emotional support animal, how do you treat service animals versus pets, and how do you kind of maintain your good customer service with your guests when, there might be situations when you have concerns about an animal that's being presented as a service animal that may not be behaving or following the rules. And also, how do you kind of navigate a situation where a guest, may be taking advantage of the limitations that exist on questions about service animals. So this is a good area to kind of think through what your policy is going to be, how you're going to handle these interactions in when they are a little bit more tricky, and how are you going to make sure that your folks who are interacting with the guests know the right thing to do. And with that, we wanted to, and I'm sure Jordan will have a chance to look to see if there are any questions while I'm going over these last few slides, and feel free to jump in, Jordan, if you want. But we did include in the slides the remainder of the 2024 Labor and Employment webinar series. We are nearing the time of year where we start to plan for next year. So we do take requests, so feel free to reach out if there's a topic that you really would love to see from our team. We're happy to consider it for 2025.
Some good questions. If the retail store website only gives the address, products available, and contact info, no purchasing is done online, does the website need to be accessible? And that's a good question, but I think the answer is still yes. Someone can't claim now that they can't purchase because that no one can purchase, but someone can claim that they wanted to go visit the store and they couldn't get the address. They didn't know what products are available. And the products, that's a big one because if I'm in a wheelchair, it might be, difficult for me to get to the store. And it might, take a lot of effort and a lot of people involved to help. And to not be able to see what products are available or not be able to see the contact info for who to call, I think would be a problem. So if you have a website, your place of public accommodation, and you have a website that provides any information and it's accessible to someone without a disability, it also should be accessible to someone with a disability. Next question. Is TDD, TTY antiquated? If so, what's the most current replacement device? The most current one, it's something called RTT. I believe it's real-time text. I'm not exactly sure how it works, but people in the know remember that acronym RTT, and it sends texts as they are typed. It allows the recipient either to be read the text, I think if they're blind, or if they're deaf, be able to read the message exactly as it's being written. And I think it's just the new, as you say, just kind of the new version of TTY. If you want to email me more, I can find out more information exactly how it works and give that to you. Do you have recommendations for tools to use to ensure PDFs are accessible when the original Word document is not available? And this is for organizations that need to host PDFs on our website. The Adobe Accessibility Reviewer can be a bit tricky for some folks to navigate, and I agree, that is tricky. If you want to email me, I can give you the names of some consultants. Although that is tricky. Sometimes this is a relatively small job, and some of the consultants kind of don't want to, quote unquote, waste their time just converting a menu to PDF. But that's the best I can do. I don't, I'm the lawyer. I can tell you, about the accessibility, but I can't tell you exactly what tools to use to make it accessibility. I got to stay out of my lane when I know so if it's actually using the technology, that's where my knowledge goes south a little bit. And I think that looks like it's all the questions. So I think that's really all I have to say. Megan, anything else from your end?
I think that's it. Just reach out if you have any other questions, or you want to chat through any of this stuff. And just remember that all of our, webinars are available to access even after the fact. So yeah, feel free to reach out if you have any questions. And thanks so much for joining.
Oh yeah, I don't know if we have. Oh, here's our contact info. I guess that there were a few more slides, but they were just wrap up slides. Here's our contact info. Yeah, Meg and I are always happy to answer any questions, talk with you further. If you have any more specific issues that you didn't feel comfortable putting in the chat, we are available. And thank you very much for attending. And we look forward to speaking with you at future webinars.